Great. Welcome back to House Healthcare. We're now moving on to I'm not going to say last section because we haven't done the effective dates yet, but this is the last section we will be reviewing on S37, section 14, and it begins on page 24, and it's around protected health information. So we just lost David, I think, so we're going to start with Lauren. Is he coming back in?
He may have already gone.
Okay.
It might be on the same thing.
Looks like he's there.
David, are you there? Oh, there he is.
Sorry, I had to switch. I wasn't getting any audio on my other device.
Oh, that is important. Thank you for joining us again. So I was just saying, we're on section 14, and we're going to let you kick off the testimony.
Sure, I think I can be quite brief. For the record, I'm David Herlihy. I'm the Executive Director of the Board of Medical Practice. And also I'll mention today, I'm also the Director of Hospital Licensing because that I'm going to mention something that has to do with that too. Section 14, I just want to say that we worked over in the Senate and a lot of changes were made. All of our concerns, when I say I'm speaking both to concerns of me and the board and the council who represent us as well as OPR. We discussed it too, and I don't want to put words in their mouth. They're going to testify, but we all worked on it together is the message. And our concerns were heard and well addressed in the bill, but I just noticed a couple more things in preparing to testify today, and I've shared those already with Jen. So we just wanted to ask for some I think small changes. With regard to the hospital licensing, I wanted to add in section 14 it would be at the top of page 26. That section, the section ends with a subsection about disclosure to the Vermont Board of Medical Practice or Office of Professional Regulation is applicable in connection with a bona fide investigation in Vermont of a licensed, certified, or registered healthcare provider. I asked about adding subsection 6, which would say to the Department of Health or Dale, because Dale works with us under an MOU doing the investigations of hospitals, that if the disclosure is to the Department of Health or Dale in connection with a bona fide investigation of a licensed healthcare facility.
And you have that?
Yes, we do now.
Okay, great. Okay.
So we had I shared that with Jen yesterday and discussed it with the Laurens and let them.
And Lauren Lehman's here, so she'll be up next.
Yes, and okay, and I'm sorry, I've got to. Okay. When I switched devices, I didn't. Then I lost my documents that I had opened, so I had to go open up on my other device. There was that, and also with regard to the part about the Board of Medical Practice (OPR) investigations, we also wanted to add one more clause. Sometimes we do investigations that aren't about a licensee, but they're about unlicensed practice. So we had talked about language adding one more clause that says, or a bona fide investigation of whether an individual not licensed in Vermont to practice a healthcare profession engaged in unlicensed practice in Vermont.
That would be a section 7.
No, that
section
would
7,
be,
but,
that would be added on to the end of subsection 5.
okay.
David, could you say that again?
Sure. So at the subsection 5, which begins at line 20 on page 25 of the as passed by Senate version, that says the disclosure is to Vermont's Board of Medical Practice or Office of Professional Regulation is applicable in connection with a bona fide investigation in Vermont of a licensed, certified, or registered healthcare provider. And we wanted to put a comma there at the end, and Jen already has this by email, but say words to the effect of I'm sorry, I'm looking to find the right line, because Jen and I went back and forth on this. Or a
It's
bona fide
easier. Okay.
or a bona fide investigation of whether an individual who is not licensed to practice a healthcare profession in Vermont engaged in unlicensed practice in this state.
Thank you.
Okay. Any other additions or changes, David?
No, that I think was it.
Okay, I think we have a couple
Yes.
questions. Do you have time for a couple questions?
Absolutely, sure.
Great. First, Daisy. Sorry, she
Okay.
goes first, and then.
So I think the language that you just spoke to sort of addresses the practices of an individual. And then under 3B, or no, that's 4B, it speaks to a covered entity or business associate. But what if we're dealing with someone who won't sign a BAA and someone who's not a covered entity?
Well, I think normally, so these would be, they shouldn't have the records if they're not a covered entity or a BAA. I mean, those are the people who we're going to looking for records in the course of our investigations, whether it's, a physician in a private practice or one of our larger healthcare systems that holds the records on behalf of all their medical staff, or in the case of the hospital licensing investigations, I talked about the hospital themselves being the holder of the records about care that took place in their facility. So it really, I think all these records will be either with a covered entity or a business associate of the covered entity, or else there's something very wrong already. So
Because they're providing reproductive health care? I'm sorry, I'm just trying to orient myself in terms of is it because they're providing the services or simply because they have the PHI or both?
well, it's they have the PHI, and these are in the course of our investigations. We're the law speaks to restraining a covered entity or a business associate from disclosing this information, and the sections that we're talking about now are sort of what's recognized as, well, we still need to, in certain situations, we need to make sure that they know they can turn it over for legitimate purposes. And so that would be, these investigations that are occurring within the state and for our internal state purposes.
Thanks.
Mari?
Thank you. As I think about my question, I think it's actually something for OPR, but last week I mentioned two concerns I had about scope of practice in two areas. One, who is qualified to perform informed consent for a procedure like a transvaginal ultrasound. And then another question was about who has the scope of practice to interpret the results of a sonogram. And I'm speaking from my experience as a nurse. I can perform procedures using ultrasound, like a central line insertion, but it's not within my scope of practice to then turn to the patient and tell them they have an occlusive thrombus in their brachial vein. Do you have thoughts about that?
I have some thoughts. I think when we don't talk about scope of practice quite as much because obviously physicians have an unlimited scope of practice.
All of it.
I mean, we talk about it a little bit. And in fact, we talked about it a little bit in this committee with regard to another bill talking about, whether or not it's within the scope of practice of a radiologist assistant to be able to make communications about what they've seen through imaging in the course of a procedure directly to the patient. And that is really constrained. I will say that it's very constrained, that the radiologist assistant cannot make statements in any way about a diagnosis or facts about what they've seen that would support a diagnosis to the patient that is within the scope of practice of the radiologist and not the radiologist assistant.
Thank you.
But the OPR is much more focused on those issues. They probably can speak to it more fully than I can.
Yeah, I think both for the advanced practice nurses, and naturopathic physicians.
Art?
Yes.
Yes, David, I'm wondering in this section how this protection is different than other protected medical services, and why is it necessary to make it different in terms of the protection?
Well, I think the overall structure of the bill is intended to create heightened restrictions on the disclosure of certain PHI that relates to these defined procedures. And so, yeah, I mean, that's really what it amounts to is that, if this bill were to pass, it reflects a new, public policy position of the state of Vermont that these matters, the information has heightened protection, and we're used to dealing with that. There's in federal law, it just brings to mind for me, in federal law, we deal with it quite often. There's special protections in it's known as 42 USC Part 2. You may hear people talk about that. It provides extra protection for records of substance abuse treatment. And we actually have to go to a court to get an order when we need to get records that relate to substance abuse treatment. Sometimes there'll be a question about whether or not practice was appropriate in providing medication-assisted treatment for substance abuse disorder. And so this is kind of the just a different form, but the same idea that certain things aren't going to be shared unless there's additional standards met. And this section creates those standards. Does that answer your question?
Yeah, pretty much. So not all medical procedures are treated the same, is what you're saying, that some require this added protection versus some that don't.
Sure. Yeah. I mean, and the, the substance abuse treatment is just one example. And
Right.
you know, I'm not an expert on the reasons why, but I know in general it was, there's a lot of stigma that goes with substance abuse treatment and or that can go with it. And there was an intent to avoid having people be deterred from seeking treatment because of the risk of disclosure, and based on that potential for stigma. And here the reason is different. It's to avoid disclosures that might result in actions that could deter access to this these forms of treatment that are being defined as legally protected healthcare activities. And so that's the basis in this instance.
Okay, so let's get back to the basic question which we started with when we started looking at this whole bill. If someone is treated by a doctor in Vermont who's out of state, in a state that doesn't allow that type of activity, if they come after the doctor or require information back to Vermont, to this doctor, does that meet the 1 through 5, now to be 6? Does it meet that criteria for that information to be disclosed or not? Typically, or maybe that's hard to answer. I don't know.
No, another. I mean, my reading of the bill, and I really focused on it in that way. I'm mostly my focus in reviewing this has been, will the board be able to do its job? Could there be situations where we wouldn't be able to get the information we need to do our job to protect Vermonters and address inadequate care? And I think that, with the small changes that we already discussed a few moments ago, that we would be able to. What you're asking about, is this going to avoid a situation where another state's medical board or another state's criminal prosecutors would be able to get the records? I'm not really the one who
Okay.
necessarily
Don't
be
want to put
advised.
you in that position. I just wondered.
Yeah.
Thank you.
Any other questions for David?
I have one follow-up if no one else has a question. I don't want to hog the show here, but one concern I have in this is I don't think anywhere in the bill is there anything spelled out. I noticed one says by the patient or the patient's conservator, guardian, or other authorized legal representative. Can I take that to mean parent? Is that parent fall under those 3 types?
I'm hesitant to give an answer because I haven't done any research on that point and like scrutinized it for that. We it can get complex, and there are certain areas like with mental health care, sometimes people who are minors under age of 18 are able to seek care without their parents' involvement or knowledge. And so I haven't teased through all those issues.
Okay. To me, that's a very important distinction to be made. It would seem that a parent could authorize that, in my opinion, for a minor. Thank you.
All right. Thank you, David, so much for coming and
Thanks.
talking to us. We're gonna have Lauren come up. You're free to stay or go, whatever fits your schedule. Thank you very much.
All right.
Lauren, join us again. Oh, yeah.
Good, how are you?
Long time no see.
Hello, everybody. Again, my name's feeling very short here. But I'll just stay short, I guess. I did. Hi, my name is Lauren Lehman. I'm General Counsel for the Office of Professional Regulation for the record. I'm here to testify on Section 14 of S 37. As you've discussed, it creates an exemption for covered entities, which include health plans, healthcare providers, and healthcare data clearinghouses under the federal law. Those entities are, if they're trying to transmit medical records electronically, are prohibited from doing so except for certain purposes and for to certain entities. And the federal law sets the floor, states can build on that floor, and this would be an addition to build on that floor of the federal law of protecting protected health information, or PHI. So the Section 14, as I understand it, would create a prohibition on disclosure of information regarding legally protected healthcare services for certain purposes. And it creates some exceptions for those on that prohibition, including an exception for disclosure to OPR or the Board of Medical Practice for a bona fide investigation of a healthcare provider. OPR is very supportive of this. On the Senate side, initially OPR wasn't included, and when they addressed that, and so we're included in that. Circumstances where we might ask for this information might be if we're investigating somebody for unprofessional conduct. And so we would want to have access to the records, especially if the complainant, in circumstances, maybe the complainant has filed a complaint, is a patient, and wants to have those records disclosed for the investigation. And there are other circumstances our investigators might need that information. So I think, and we've collaborated with the Board of Medical Practice and Jen last night to add on that provision at the end that allows to access documents not only for licensed healthcare providers in Vermont, but also those seeking licensure in Vermont. And we're very supportive of this, and we're happy to be included in the exemption.
Thank you. Any questions for Lauren?
I just realized that my question, it's not about the section, so
I was wondering where you were going with that.
not gonna ask it again. You already heard it when I asked.
And Lauren's back with us tomorrow. You might be able to ask it then.
Okay.
Any other questions on this section?
Well, I am curious about, or question about parent, and what does that answer?
Like David, I have not specifically looked at it. It's a legal representative, and so however the court determines who legally represents the client or the patient would be allowed access or allowed to grant that permission for disclosure as the law is written. That's my understanding.
It wouldn't be automatic then. It would have to go through a process. Is that what I'm understanding?
So this is not
Yeah.
Lauren's section, so I have an asterisk next to that, and we will come back to it.
Okay, thank you.
Great, thank you, Lauren.
Thank you.
And lastly, we have Jessa.
Good afternoon. Thanks for having me. Can you hear me all right?
Yes.
All right. Jessa Barnard with the Vermont Medical Society. And I will just echo what Lauren and David said, that we worked really closely with Legislative Council and the members of the Senate to sort of clarify this language. This is an area that's fairly complicated and confusing for healthcare providers. So rather than with the regulator lens, but with the healthcare provider lens, I'll say when and when not a healthcare provider can disclose records in the course of litigation can be hard to understand in general, not just in this area of protected health information. And so we really appreciate the clarity of this language. I think it really helps healthcare providers understand when they can and cannot disclose this information in a subset of cases dealing with protected healthcare activity. I wish the law was this clear in all the other instances. So we strongly support this language. I mean, there are all sorts of types of litigation in which healthcare entities are requested to disclose records. It could be, workers' compensation cases, car accidents, malpractice claims, a whole host of reasons you could be getting requests for records from lawyers, from courts, from others when you're a medical practice. And again, it's not always, HIPAA is not as crystal clear as it could be on when you can disclose those records. So this is very helpful. The piece that we particularly think is important is if you look under subsection 3, where it says that disclosure is ordered by a court of competent jurisdiction. And then it says that that order has to include the court's determination that good cause exists to require disclosure of the information related to legally protected healthcare activity. So that's Representative Peterson. I think you were asking, how does this differ from HIPAA in general or disclosure sort of in legal cases in general? This is saying that the court has to be very specific and sort of make a specific finding that this is that there is a reason to disclose this information, even though it's related to legally protected healthcare activity. So it both tells the court what they have to look for and tells the healthcare provider, like, okay, this is a valid court order that now you need to follow and you can disclose the records for these purposes. So that was an addition that actually I think Professor Cohen suggested. One of the other attorneys giving input on this bill suggested. I will, from our interpretation of HIPAA, to also Representative Peterson's question, an authorized legal representative does include a parent of a minor in the instances that HIPAA allows the parent to consent to the minor's disclosure of the minor's records. So if anyone who is able to stand sort of in the place of the patient and disclose records, including if that's a parent, would be included in that language. So again, it's not as David Hurley was saying, it's not always a black or white question. There are instances where a parent can disclose a child's or minor's records and instances when they can't. But this is basically saying follow the HIPAA rules. Whoever under HIPAA can sign that form, disclose, asking for the release of records, would be the one who could agree to it in this for this purpose as well. I don't know. I'm happy to answer other questions. I think Lauren did a nice job just kind of generally describing how this, what HIPAA does and how this also relates or adds to it. But I'm happy to try to clarify any other questions.
Great, thanks, Jessa. Any clarifying questions? Art and Leslie did that. I'll let you go, Art, but that answered your question on that one. Go ahead, Art.
Yeah, let's beat up on that a little bit, Jessa. So you say parent does fall under one in the language on page 25. Okay, but not on everything. So if a parent wanted to say, I want to see if my child has had gender affirming care, can they do that?
In some instances, yes. In some instances, no. I think so my understanding of, gender affirming care is a particularly complicated area because it includes so many types of healthcare services. But so my understanding for gender affirming care is that some of those services would fall under mental health therapy, for example. And in that instance, minors, do I have my age right? Over 14, I believe, 12 or 14. I forget the actual, I'd have to look back at my list here, can consent to those services. If that's the case, then the minor, whoever consented to those services, also controls the release of the records related to those services. So in that case, then it's the minor who controls those medical records, and the minor would have to be contacted to say, do you consent to disclosing these? For any other types of gender affirming services, so if there's any prescription medications involved or any sort of medical interventions of any kind, those require parental consent. A minor cannot consent to those. And in that case, the parent also controls the release of records. So the parent would have to be the one to say yes or no, you can disclose them in this context of litigation. And just to be really clear, this, if you look under little c in this section, this is only related to release of information in, as she says, civil or criminal actions, probate, legislative, or administrative proceedings. So this is not sort of all disclosure of healthcare information for sort of, we think of HIPAA relating to treatment. If you want to send your records to another healthcare provider, healthcare operations, saying you can talk to your insurance company for billing purposes. So this whole section of this bill does not touch a lot of that day-to-day exchange of healthcare information.
Thanks for bringing that up.
Yeah, it's just, so really this is trying to get at an out-of-state legal proceeding where we're concerned that it may be pretext for just receiving and then potentially disclosing or using in purposes Vermont wouldn't want healthcare data to be used. So for political reasons, to expose it, maybe they wouldn't be following HIPAA the way we would want them to. So just to be clear, I just want to be clear about what the intent of this section is to say, no, we don't want to disclose it for out-of-state lawsuits because those might not actually be about what we think they should be about. It's not just about getting good healthcare for somebody. It's, let's see if we can go on a fishing expedition here, get somebody's records, see if they were doing something in our state we don't believe people should have access to.
Okay, but in the other case, just a general thing, a parent can request and get those for some of it.
Correct. And that wouldn't, yes, and that, right, that won't, so the parent saying, I just want to see, what happened in this medical appointment.
I want to know what's happening to my
Right,
child.
I want to know what care my child just got. This section doesn't touch that at all, because that's not litigation. So that just falls under the general HIPAA rules around disclosing information, which we went through is typically the parent does have access unless it's the kind of services that the minor under state law has the authority to consent to themselves.
Thank you.
Sure.
Laurie and then Leslie.
Jessa, this is a stretch, but do you see the possibility of where a parent who does not support gender affirming care, it wouldn't happen because they'd have to consent to any medical or prescription therapy. So the only thing, I was thinking of a parent who, in a situation where a child was not really well supported by the parent, or maybe even in a dangerous abusive situation, and the possibility of the parent getting a hold of PHI and sending that out of state, or and this doesn't address that at all.
Correct.
Leslie?
So I'm understanding that different states can have different laws, I should look that way, regarding the care of minors and HIPAA. And I'm wondering if Vermont has any laws on that currently.
I'm sorry, can you just
around consent, minor consent and HIPAA?
So
different states I think are allowed to have different laws under HIPAA, if I'm understanding that right.
So states can be more HIPAA sets a floor.
Yeah.
So you follow whichever is more protective of PHI. So if HIPAA is more protective, you have to follow HIPAA. If the state law is more protective, you follow the state law. So an example is what's proposed in S37, where HIPAA says you can disclose information in the litigation context in more scenarios. Where what S37 is saying is actually we're narrowing those scenarios to the list of 1 through, what is it going to be now, 6 reasons, whereas HIPAA is broader than that. Consent is different. HIPAA doesn't really address consent. I have to put all my HIPAA memory back on here. I could be a little not 100% accurate here, but in general, HIPAA says you follow the state law sort of on consent to care. And so in those, Vermont does have, it's Vermont law we look to say, can a minor consent to something? Where HIPAA might say, then in that case, you follow kind of the that directs who can then release those records and is considered a legal representative to disclose records.
So that's Vermont law. Vermont does have law that's built higher than HIPAA
In some situations, yeah.
for minors. Okay, so here's one example. Are there other examples of mental health treatment, I guess, in general, counseling, that kind of thing?
So I think that's conflating consent
Yeah.
and HIPAA.
Yeah.
HIPAA's really about, for the most part.
No, I'm not. I guess I'm not. I'm probably just using the wrong word. I'm sorry. The idea is release of protected health information. And I'm just wondering, are there other examples in Vermont where protected health information can be released? Let's say that protect minors from others getting those records, other than this.
Yeah, I think I understand your question. And so in
sorry.
general, if there is an area in Vermont law that allows the minor to consent to that care, then the minor is supposed to control the release of those records. So the list, I don't know if so I don't, that is consistent. It's not just in these areas that this bill addresses. So I think Legislative Council was kind of going to be giving you that list of what minors in Vermont can consent to or not. And in any of those areas, so like STI prevention, for example, or emergency care, those sorts of examples, then in those instances, the minor can say, yes, please send these records to my primary care provider, or, no, don't release these. So if the minor has consented, they generally can control that information.
Thank you.
Thank you, Jessa. Any other questions on section 14 specifically? Great. Thank you, Jessa, very much. Thank you, David.
Sure. Thank you.
Have a great day. And so for us, I want to walk through a little bit for tomorrow. 9 a.m. we have a joint meeting with Senate Committee on Health and Welfare. 10:15, we're having Michelle Childs, Legislative Counsel, and remember to do a summary of H89, which is the companion bill to 37, so we kind of understand that and get some of the issues figured out of what's what, where. And then we will have Lauren Lehman back with us again, and to just she has some language suggestions for one of the sections, and I know we have some additional questions for her of the House floor. And then at 2:00, we will have Wesley Pitcher and Lance Pitcher. So Wesley is a transgender male. Lance is his father. So we will hear their stories. And then at 3 p.m., we have testimony from Planned Parenthood, just general testimony. And then 3:30, we're going back to section 9, which we had some questions about. And then at 4:00, we have Legislative Counsel here to just walk through some consent and some other issues that were raised. And then Thursday, we are spending the morning walking through the bill. There'll be some markup that will already have been done based on what we've heard. We'll go through each section, see where we are, see where the language is. Not really intending that we take, unless something new comes up, and I'm not thinking we take any more testimony. We'll be at the point to mark up the bill and then potentially vote on it on Friday. So that's kind of where we are. We'll squeeze in there as 47.
So during that time, is that where we do more discussion?
Yes, okay. We'll definitely have a lot more discussion. Yes. So that is where we are. So we will see you here tomorrow at 9:00. Have a